Today, at least 4 of the 6 conservative Supreme Court justices seemed open to upending years of precedent and ending the long-standing tradition of local school boards determining the class curriculum for everyone. Instead, they seem inclined to allow the judicial branch to step in and force public schools to provide opt-out options to parents who object to LGBTQ books. At issue is whether a school district in Maryland is permitted to require elementary school children to sit through lessons involving books like Uncle Bobby's Wedding, where a niece worries that her uncle will not have as much time for her after he gets married to his male partner. In the past, lower courts ruled that mere exposure in public school setting to ideas or information that conflicts with a person's religious beliefs does not amount to an unconstitutional burden on religious rights. Joining me now, Melissa Murray, NYU law professor and MSNBC legal analyst and co-host of the Strict Scrutiny podcast. Did I explain that correctly?
No, it was a great explanation. And you can see why it is a big deal. This is a collision between public education on the one hand and religious liberty on the other. And much of the oral argument today was spent with the justices haggling over whether there could be a limiting principle. Can you acknowledge the fact that individuals are plural, they have different religious beliefs, and they may have religious beliefs that object to this kind of contact, and you can still have a school curricula, and you don't have parents saying, I can't do that, I can't do that, I can't do that. And instead, you have a curriculum. And we've had decisions in the past that essentially say that, yes, you may have deeply held religious beliefs, but mere exposure to this content doesn't conflict with those beliefs. It doesn't influence you or coerce you to abandon those religious beliefs in any way. It's simply exposure. And I mean, this could be a monumental decision for this court if it takes a very maximalist approach to religious liberty, and it has been trending in that direction. We could have a situation where parents object to a teacher being gay, and suddenly the students have to be moved to a different classroom. Or you might have something even more consequential. My teacher is a woman, and my religion says that women are supposed to be in the home. Therefore, I cannot be in this classroom with her. And so where's the stopping point? Where do public schools get so mired down with these kind of opt-out provisions that they can't actually put on a public school curricula? And some have argued that maybe this is the point, to really break public education as a whole in this country.
You called that the maximalist approach. What are the other 2 paths they could take?
So the maximalist approach is sort of full religious freedom. They get the chance to opt out. The second approach would be narrower and would focus on the record here. One of the things that the court below said is that we didn't actually know a lot about how the schools use these books in their curricula. Was it a situation where teachers were actually talking about gay marriage with kindergartners? We just don't know. The court below said that the record below was threadbare. And so one option the court could pursue is to simply remand this back to the court below to make greater findings about how these materials were being used in the curriculum. Another option is one that the court pursued in a case called Masterpiece Cake Shop in 2018, and it focused on the school board's language when it decided to rescind the opt-out provision. So in this case, the court would send this back, or would not send this back, but rather would look at the school board's language here when they removed the opt-out permission. At that point, the school board have acknowledged to their lawyers that they used intemperate language. And so the court could simply say that there was animus to religion and simply decided on that narrower ground rather than making this broad exemption for religion. So 3 different off-ramps.
Well, because there was a lot of attention today on this question of opting in. The lawyer explained, because as you know, this district originally did offer an opt-out option.
As many school districts do.
And then found it logistically really complicated to actually administer. Here is the lawyer explaining why they stopped offering that opt-out option.
They changed in mid-year and say no more opt-outs. I'm just not understanding feasibility.
So again, I think what's in the record is that with respect to these books as they were deployed in the classroom, there was high absenteeism in some schools. For example, dozens of students being opted out. If you have dozens of students walking out, making arrangements for those students to have adequate space and supervision and alternative instruction, I think is infeasible.
So essentially what Alan Schoenfeld, who was the lawyer arguing for the school board, was saying is that when you have these opt-out provisions, and a lot of schools do have them, it really just leaves the school board in this position where parents can actually fly spec the curriculum. I don't agree with that. I don't agree with that. And then suddenly the school board is essentially crafting a bespoke curriculum for each child. And that at some point becomes really unfeasible. And it seems very logical in this case, like these are young children. Maybe you just let them opt out. But again, who's objecting to what? And in a plural community where there are so many different religious beliefs, so many different beliefs about so many different things, you could have a situation where every parent is objecting to everything at different points in time. The school board has to accommodate it all.
Right. Not surprising that this case came from one of the most religiously diverse school districts in the country. Real quick before I let you go, you had Alito, Kavanaugh, and Gorsuch all focusing on the question of how these books amounted to coercion.
Right.
The family's lawyer repeatedly using the term indoctrination. What are they doing here?
The idea here is to show that when children are merely exposed to these ideas, that is tantamount to indoctrination, and the First Amendment forbids that. So the question is, we've allowed opt-out as just a courtesy that school boards have offered. The question here that they're really approaching is whether or not it is a constitutional requirement because of religious liberty to require that school boards provide this to parents. And the school board argues that would essentially break public education as we know it.
3 paths they could take. We will keep our eye on this. Melissa Murray, thank you so much.
Thank you.